Good morning, everyone. I'd like to welcome everyone to Thompson Hine's Professional Conduct webinar. My name is Rob Johnson. I'm a partner in the Business Litigation Group here at Thompson Hine, based in the Cincinnati office. I am delighted that we have with us today as a guest speaker who'll be presenting on mental health, Lori Mihalich-Levin, JD. She is the founder and CEO of Mindful Return, author of Back to Work After Baby, How to Plan and Navigate a Mindful Return from Maternity Leave, and co-host of the Parents at Work podcast. She is the mama to two wonderful redheaded boys, ages 7 and 9, and is a partner in the healthcare practice at Denton's US LLP. Her thought leadership has been featured in publications including Forbes, The Washington Post, The New York Times, Parenting, Thrive Global, and The Huffington Post. For the next 90 minutes, we'll be discussing professional conduct and mental health at a social distance. Before we get started, and Lori will speak first, I do want to share a couple of housekeeping items. We're offering 1.5 hours of CLE credit for today's webinar. If you are seeking CLE credit, refer to the handout section of the user control panel to access the form. Click on the form to download it, fill it out, and follow the instructions on the form to receive credit. Now, listen carefully because we've had attendees miss this part. The form is located in the GoToWebinar control panel, which should be in the upper right-hand corner of your screen. If you don't see it, click the red arrow at the top right of your screen, and that should expand the control panel. This is also where you will be able to submit questions in the chat box. At the very end of the presentation, I will provide you with the code that you'll need to complete the form at the conclusion of the seminar. We'll address questions at the end of each speaker's presentation. And with that, I'm going to turn it over to Lori to get us started.
Thank you so much, Rob. It's a true pleasure to be here. Good morning to everyone. And for this first half an hour, we're going to be taking baby steps to walk backward away from the burnout that I know so many of us are experiencing. I live in Washington, D.C. As Rob said, I wear a number of professional hats. I'm on a 50% schedule at Denton's, and in the other half, I run this Mindful Return program, and also have had my two boys who are 7 and 9 years old home with me since that fateful Friday the 13th of March. They've been doing virtual school. So I'm feeling the burnout strongly myself. I know that I can't offer you any silver bullets to this situation, except, we've got the vaccine on the horizon, which is promising. But I do want to be able to help you walk away with at least 1 or 2 small experiments that you can try, because I am a firm believer that the small tweaks that we make in our day can actually make a big difference in terms of our mental health and how we're viewing and approaching each day. So my challenge to you really is to pick one thing from the next 30 minutes and try it out for the next week. On the next slide, I am just sharing a little bit of data about burnout nationwide. So Flex Jobs and Mental Health America did a study not that long ago and found that 3/4 of those of us in the United States are currently experiencing work and life-related burnout. 1/4 is not. I'm curious to find those people because I don't think I know them personally. And about 40% of those who are experiencing burnout have said that they directly attribute it to the circumstances of COVID. Next slide, please. As a daily practice, I have tried very hard, therefore, to remind myself when things are going crazy and everything's taking longer than I want it to, and my plans are being disrupted ad nauseum, I need to remember that it's not me, it's the pandemic. And so I just want to sort of offer this reminder that we are all distracted. We are all doing something that is impossible. And I know that word unprecedented is overused right now, but we're all trying to do something that wasn't designed to be done by humans. It's the pandemic. Next slide, please. I have found that at least in 2020, with respect to a couple of things, I have had to massively reset expectations against reality. We probably entered 2020 with the new decade, the shiny ball, the everything's going to be fun and rosy, And we had all these dreams and aspirations for what our careers would be like and our families would be like. And we've had to really pivot and reorient this year. And there are sort of 3 areas where I personally have found myself recalibrating. One is personal identity. Who am I if I can't work uninterrupted all day long and, as an employee? And who am I as a parent if I'm not able to interact with my kids the way that I used to? I've had to recalibrate how long everything takes. Gosh, everything takes so long during COVID. And I've had to recalibrate exactly how much time I spend scheduling things. The jigsaw puzzle exists in our household between myself, my husband, who also works, and then our kids who have their own Zoom schedules. And pretty much everything this year has been reoriented. Next slide, please. Interruptions are absolutely the norm for many of us, and I know Rob's going to be talking about importance of ethical concerns around interruptions, but the Washington Post did an interesting time study of some folks, and what I found humorous about their display of this data is that they note not just the interruption by one child during the day, for example, but when the second child interrupts the existing interruption. So how do we maintain any concentration? How do we get any of that deep work done? How do we renew ourselves when our days look like a big, chopped up slice of a day? Next slide, please. The Federal Reserve System did a presentation a couple of weeks ago in conjunction with the chambers of commerce across the United States, really noting the childcare crisis. And this isn't a presentation, focused specifically on parents, but I did want to note that parents are dealing with something that is, completely abnormal, and about half of us actually are working remotely right now, with 3/4 of us having kids there while we're trying to work. And a majority are finding that the current childcare situations that we've arranged for ourselves or cobbled together are really unsustainable. Next slide, please. In addition to the mantra that it's not me, it's the pandemic, the other mantra that has really kept me going, both through the pandemic and when I became a working parent in general, is the Teddy Roosevelt quote, "Comparison is the thief of joy." For me, it's been really important not to focus on what my neighbor is doing, what my colleague is doing, what my manager or direct report are doing, but really to focus on what is most important for the mental health of myself and my family, and really to try really hard not to compare myself to others. Next slide, please. I wanted to give you just a little bit of a window into how and why I came to care so much about this work-life integration and backing away from burnout subject. It relates directly to the small people in my life, of course. This was my first couple of days of being a working parent. I brought my little nugget to the office, and I found it very challenging to go back to work after parental leave. On the next slide, you'll see what really motivated me to create Mindful Return, which was baby number 2, who came 2 years later and definitely caused me to go off the rails in a number of ways that I had not really predicted. Next slide, please. You'll now see the larger version of these small peanuts who, definitely lead us to battle the dark side on a daily basis. Next slide. Okay, so let's dig into the meat of the conversation today. And we've got 2 areas that I really want to focus on as we think about bringing ourselves down from burnout on a daily basis. One thing I want to say before we dig into these 2 areas, though, is I find it helpful for myself to, at various points, whether it's in the morning when you wake up or at some point, to really think about where you are on a burnout scale of 1 to 5 for today, where 1 is like you just got back from a wonderful beach vacation, and 5 is that you are really like about to jump out the window. So if you can note that for yourself on a regular basis, you can start seeing what causes you to be going up in the burnout scale and what causes you to come back down. Okay, but first let's talk about practical time management strategies for how we can regain some focus, and then we'll turn to how to manage that energy so that when we sit and have some time to work, we're actually able to be present and do that. So in terms of practical time management strategies, I've got 4 for you today. And the first one, which you'll see on the next slide, you may have heard of before. It's called the Pomodoro method. And the concept of the Pomodoro method was based on the Italian tomato called the Pomodoro tomato and the kitchen timer that's named after it. Of course, you don't need to have that actual timer on your desk. You can have your phone or any other timekeeping device. And the concept is that you work on one project and one project only for a 25-minute period, and everything that might ding at you is turned off. right? The Slack notifications and the text messages and the email, and it's all shut down for 25 minutes. And, during that time, your mind will wander, a child might come in and interrupt you, something else will happen, and you just deal with that interruption. You write down the thing that caused your mind to wander, and you come back to the task at hand. After 25 minutes, you take a 5 or 10-minute break, you get up, you move around, you stretch, you check email, and then you go back to another Pomodoro, as they call it. The neuroscience research shows that a series of 3 Pomodoros is supposedly optimal for the human brain, and then that's followed by a longer break. I'd say during COVID, if you do one of these per day, you'll probably feel infinitely more productive than you did before. The reason why a system like the Pomodoro method works is described in Cal Newport's wonderful book, Deep Work. Cal Newport is a computer science professor at Georgetown and has written a number of really, really wonderful books I'd commend to you. One of them is Deep Work, how we get into that state of concentration. He says that the reason that the Pomodoro method and something like it works is that we don't have to mentally litigate again and again and again what we should and shouldn't be doing. I don't know about you, but I could probably spend 80% of my day trying to decide what to do at a given moment. So this takes away that opportunity for trying to decide. The second strategy on the next slide is Daniel Pink's most important task concept. Now, Daniel Pink's an author and a writer, and he has this wonderful Pinkcast, which is his version of a podcast. And it's, short 1 and 2 minute clips on ideas that he finds helpful. And on one of them, he talks about this thing called the MIT. It's really simple. This is not rocket science. This is, literally doing the most important task first. But what I find really compelling about it is, the concept of writing it down and doing that task before any of the stuff that would otherwise give your brain those dopamine hits of checking little things off, right? So for me during COVID, it's been most helpful to go the night before and write down on an index card what is my absolute most important task for the next day, put that on top of my laptop, and then whenever I am able to sit down and work, whether that's first thing in the morning or after dealing with a number of other kid issues, that is the thing that I turn to. It gives me some confidence to go to sleep at night knowing what I'm going to be working on the next day. The third time management strategy on the next slide is the Eisenhower matrix. Now, this is a system that was based on some principles that were created by General Eisenhower, President Eisenhower, and that was really made popular by the author Stephen Covey. And we set up 2 axes here along the ideas of things that are important. So we're weighing the importance of a task, and we're weighing the urgency of a task. Now, before you use this matrix, I would strongly encourage you to do a brain dump list making activity, which literally means getting everything that's on the to-do list swirling around your brain and putting it onto paper. This is something that I do every Saturday as a matter of habit. I've got one list for life, one list for my legal work, one list for mindful return. Just get it all out of that prefrontal cortex so you don't have to be worrying about it. Then you can go through each task and figure out where it fits on this the quadrants here. I'm going to walk you through the four quadrants. The top left one is the things that are urgent and important. And being a professional who gets your work done and a person who accomplishes things that you need to do, I'm not going to spend time talking about this one because that's the stuff that needs to get done, and I know you do it. The bottom left-hand quadrant is the things that are not necessarily so important to accomplishing our goals for the day, but they purport to be urgent, right? So those are the things that flash at you and ding at you, and the text messages that you feel like you have to respond to immediately, but actually maybe it's not that important that you do. And there it's important to postpone, block a time that you'll address that sort of thing, perhaps at a time when you don't have to have deep concentration, when you know that you could maybe be monitoring somebody else doing their schoolwork while you're responding to those messages. The top right-hand quadrant is what I would wager is probably the most important for our careers and for our families. And those are the things that are really important, but they're not urgent. And I know this has been a real struggle during COVID for us to manage things that don't have a deadline in a world where our time is just so diminished and depleted. But here, this might be, it would be really important and helpful for you to publish that article you've been working on, or to set up a mentoring conversation, or to have a family meeting about a particular subject that's really been bothering everybody. But there's no deadline on it, so what's the pressure? So what I really recommend here is both planning a time, and scheduling a time to deal with that issue, and also finding an accountability partner with whom you can check in about that subject. My husband and I have a weekly Saturday meeting that I'll talk about in a minute. But one of the things that we talk about at the Saturday meeting is like holding ourselves accountable, putting ourselves on the hook for that thing that we know is important, that like we know we should do that thing, but you know, making sure that we check in with the other person about whether it actually got done. Finally, the last quadrant on here is probably my favorite COVID quadrant, which is the stuff that's really not that important and not that urgent, so we can eliminate it. So there are things, in fact, on our to-do list that never need to get done, or at least don't need to get done right now during the COVID situation. And so, you know, those are the things that just need to go out the window. On the next slide, I've got my fourth and final time management strategy, which is a concept that I call my Saturday basket. And it's really a way of consolidating chaos of a life, of a household, into one place. Cal Newport, in his book Deep Work, talks about the ability of incomplete tasks to dominate our attention. I don't know about you, but I could probably spend 15 minutes worrying about the thing that takes me 15 or 20 seconds to complete. And so for me, the idea of consolidating all of those little pieces into one place brings me and my family a lot of calm, joy, and just not having to deal with miscellaneous tasks and items throughout the week. So basically, we call it a Saturday basket because it's all the stuff that we deal with on Saturday evening. Saturday night, my husband and I have a hot date on the couch. We sit down, we go through the stuff that's in the basket. This is literally in our old house, the basket on top of the microwave. And we sit down and we have a meeting to talk about the week and to plan out what's coming up and pay, you know, the bills and fill out the permission slips and all that stuff. We don't do any of it during the week. We only do it on at that one time. On the next slide, I talk a little bit about what exactly goes on in our Saturday meeting. We deal with the next week's schedule, who is on point for childcare on any given day, a rough outline of what we're going to eat. We have a monthly bill paying conversation. We literally map out who is exercising when so that it actually happens, order the things that are on Amazon, fill out the permission slips. Pre-COVID sniff, we used to plan monthly date nights. I'm sure that will come back at some point when everything is back open. I also want to point out, especially in terms of the mental health piece, that scheduling time alone and scheduling time with friends is really, really critical. For my husband and I, we trade off, at least since COVID has started, and after we had maybe 3 or 4 months of like really dismal burnout, we decided that we were going to start swapping off 3-hour chunks on weekends. So I get 3 hours on Saturday, he gets 3 hours on Sunday. We each do whatever we want. I put my earbuds in. My children know that they're not even allowed to talk to me. And I either wander the neighborhood or read a book or read the Vinca or do something that I know is going to be calming and restorative for myself. The last thing that we do at the weekly meeting is to reflect on the week's mindful moments. And really, this is an opportunity to just look back over the week and say, oh, what didn't I share with you that was actually kind of sweet, or that I want you to know about what happened either at work or something sweet that the kids said or did. So I think it's a nice chance to just pause and in a really intentional and scheduled way, have that reflection. It could be with your best friend, it could be with a partner. You can sit down and reflect on these things yourself as well. Next slide, please. We're now going to transition into the energy management piece, because even if you have all the time in the world, if you're totally fried and burnt out and have no energy to be able to continue while you're sitting and working there, it's not going to do you much good. Next slide, please. I know we don't have big chunks of time right now. I know that we don't have the opportunity to, go out and take big retreats and restore ourselves in ways that we otherwise might have wanted to. But it's okay to start small. It's okay to go micro. The neuroscience says that, it only takes 17 seconds to start transitioning our mood from a more negative one to a more positive one. 17 seconds. We can hold positive thoughts for tiny bits of time. Next slide, please. I also, in addition to emphasizing that we can do this in micro bites, I want to emphasize the importance of turning things into routines and rituals. So back to Cal Newport, my favorite Deep Work book, he says that we have a finite amount of willpower and it becomes depleted as we use it. So for some of us, our willpower stock might be depleted by like 6:38 in the morning, depending on what we've grappled with that day already. And so, we're not going to have the energy and the willpower to do some of these things that we know are good for us, but that we're just not going to bake into our day. But if they are routines and rituals and habits, we're much more likely to actually do them, because that's the thing that follows next in the day. Next slide, please. There are a couple of micro-mindfulness practices that I have found particularly helpful in resetting myself and maintaining a better sense of equilibrium throughout the day. The first of these is something that I call ISS, which is really multitasking my shower. And back when I had my second child and I was really in a dark place, somebody had said to me, oh, it helps to set an intention for your day. And I said, oh, that sounds great. I'll set an intention. And then 4 o'clock, 5 o'clock, 6 o'clock would roll around and I would have forgotten to set an intention for my day. So I came up with an acronym that I still use in the shower, probably have for like 7 years now. The acronym is, a form of to be. And the I stands for set an intention. Might be go to bed tonight at 9:30 because you are so exhausted and I don't care what isn't done, you need to do that. Or the intention might be get that one project done that's really been nagging at you. Or the intention might be play that game with your kid that they've been begging you to play. The first S in ISS stands for stretch. So I do a couple of stretches, yoga poses in the shower. And then the second S stands for savor. This is the gratitude piece. This is I'm standing in a hot shower alone. No one's attached to my leg. I have warm water. We have toilet paper. There's food. There are eggs. Like there are good things that are happening in the world right now. Another strategy that I use in micro increments really is pausing during the day. Really sort of pauses between work and home, pauses between being with family and shutting off and being tuned into work. Before COVID, when I actually had a commute, I used to stop off at a park bench or a hotel lobby for 5 minutes to sort of reorient my head between the home world and the work world. And I would turn on a wonderful free app called Insight Timer and either listen to a guided meditation for 5 minutes or just sit and breathe alone for 5 minutes. And this is something you can do even if you're working remotely, right? So now I have a couple of pausing rituals in my day. I use Insight Timer after I take a shower. These are things that you can build in small increments. And next slide, please. I've got 2 more micro-mindfulness practices to share with you. One is that I'm a huge fan of transition rituals, right? Those things that help you move from one thing to the next. Getting dressed is a good one. I think of Mr. Rogers when I think of transition rituals. He's like the consummate transition ritual dude. He's got like the sweater that he always zips up and the shoes that he always changes. Side note, I find Mr. Rogers to be really awesome for kid emotional intelligence. My 7 and 9-year-old were like totally willing to watch episodes of him for many months during COVID. We did Amazon Prime from like the 60s through the early 2000s. So it holds up his show holds up over time. But in terms of transition rituals for me, whenever I sit down to work, no matter what time of day that is, I go and I raise the blinds and I make the bed because I'm, in this home office that's separated from my bedroom. So, can you build in some sort of ritual that's going to help you pause between the breakfast you just made and the work that you're about to sit down and do? And the final of the micro mindfulness practices that I wanted to share is a gratitude practice. There's a wonderful book, you can find it on Amazon, called the 5-Minute Journal. It's a tool for remembering to have a gratitude practice and has prompts that are literally only for 5 minutes a day, some in the morning and some in the evening. You don't need the fancy book, you can just have a notebook. But there are some things that I found particularly restorative and helpful about having a gratitude practice, particularly before bed. One is that it reorients my brain from the crazy wild to-do list over to the things that actually went well during the day and that I can be grateful for. 2, it is a place for me to write down some successes and funny things that my kids say and just moments that I want to capture that I otherwise probably wouldn't have remembered. And then 3, it helps me fall asleep faster because the worry thing isn't going on. And quite frankly, I can use all the minutes of sleep that I can possibly get. So I'm a huge advocate of having a gratitude practice. Next slide, please. Okay, one more micro-mindfulness strategy I want to share with you, and I want to practice it here just for a moment, is the power of centering in our bodies. So when you watch professional athletes, and I know 2020 has been a sad year for watching sports, but when you watch professional athletes, they center in their body before they make a play, right? So this person who's setting the volleyball, she centers in her body and takes a deep breath before she serves. Before a pitch is thrown in a baseball game, if you watch the outfield, they all take a step in, right? What are they doing? They're getting their body ready. I'm not an athlete, I'm not a professional athlete, but we are all corporate athletes in some sense, right? We all have to keep our brains and our bodies charged and ready to solve the next problem, accomplish the next task. And so how do we center in our body in a way that gets us out of the spiraling mind and helps our whole nervous system to calm down? So what I want us to practice, if you go to the next slide, is just a very quick centering practice that I would challenge you to do as many times a day as you can possibly remember. And really, it only takes a couple of seconds, which I'm about to prove to you. So the first thing you want to do is to sort of sit up in your chair and feel your feet on the floor, like wiggle your toes around and feel what they're touching. And that sort of helps get your mind out of thinking about itself and into thinking about some part of your body. Then what you're going to do is you're going to take a deep breath in for a count of 4, and I'll guide you through this. And then a breath out for a count of 6. And while you're breathing out, you're going to sort of lengthen your neck and your head and your spine. And you're going to do that again and really focus on the core of your body. So everybody, feel free to practice along with me here. You can go ahead and close your eyes and take a deep breath in for a count of 4. 1, 2, 3, 4. And out. 2, 3, 4, 5, 6. And in. 2, 3, 4. And out. 2, 3, 4, 5, 6. Just notice what may have happened within your body. I challenge you to take that kind of deep centering breath before you get on a call with a client or a colleague, before you sit down to work, after you've broken up a fight between 2 children in your house, after you've gotten that email that totally triggers you. Take the deep calming breath. And for me, the counting really helps, because it's not just like, oh, breathe. It's like, oh, I know what I'm doing. I'm going to take a breath in for 4 and out for 6. Next slide, please. Also be aware of how you talk about your day. I find that language actually does really matter. When I say that I am crazy busy, I feel crazy busy. I've sort of gotten rid of the word busy in my life. And over the past, let's call it 5 or 6 years, I have come to say that my life is full. It just sort of helps reorient how I'm thinking about my days. Next slide, please. I really appreciated and took this point about the being busy, and just wanted to share this quick snippet from a wonderful thought leader named Seth Godin. He writes, busy is not the point. There's a common safe place being busy. We're supposed to give you a pass because you were full on all day, frantically moving from one thing to another, never pausing to catch your breath, and now you're exhausted. He says no points for busy, points for successful prioritization, points for efficiency and productivity, points for doing work that matters. No points for busy. I love that reframe. Next slide, please. Okay, so our last topic here is a little bit about boundary setting. I see that we're close on time, so I'm going to work through this quickly, but just recognize that boundary setting is so critical to our own emotional and mental health. And I think it's important to think about, particularly in a world where it's like work-life mush every day. Next slide, please. So being a lawyer, I always have to ask the question, what is a boundary? Let's look it up. Let's go to the dictionary. A boundary is, quote, a line that marks the limits of an area, a dividing line. So it's a boundary between yes and no. It's a boundary between one task and another, between work and home, between any 2 things, really. Next slide, please. I was putting this slide deck together, and I was about to take this slide out, and my 9-year-old was sitting next to me, and he said, you can't take out the picture of the playground. So here it is. I just wanted to offer that instead of thinking about boundaries as restrictive and as punitive in some sense, let's think about them as a source of liberation. In Greg McKeown's wonderful book, Essentialism, he writes that boundaries are a source of liberation. The truth is demonstrated elegantly by the story of a school that's located next to a busy road. At first, the children played only on a small swath of playground, close to the building where the grown-ups could keep their eyes on them, and then someone put a fence around that playground, and now they could play anywhere and everywhere. Their freedom, in effect, more than doubled. So for me, I view boundaries as very much of a freedom-enabling tool. Next slide, please. I also want to share with you my absolute favorite boundary mantra, which I repeat to myself many times a day, usually. And this is from Brene Brown. And she says that saying no is hard when you're trying to please everyone, but it's way easier than feeling resentful. Her boundary mantra, which I have now adopted, is choose discomfort over resentment. If you're coming toward me with a PTO sign-up sheet and you see me quickly close my eyes and start chanting, you'll know exactly what I'm saying, she says. So what I really appreciate about her statement, choose discomfort over resentment, is that setting boundaries is not comfortable. It's important to recognize that we all find it challenging and that it's not easy, and yet it is often so critical to not being resentful about the actions that we're taking. Next slide, please. In order to set healthy boundaries, it's really important to be able to say no in a calm and thoughtful and productive manner. And so I just wanted to offer you this sort of very quick 4-step process for how on earth we can say no without burning bridges and with, by maintaining really strong and healthy professional relationships and personal relationships. So the formula that I like to follow is first to express enthusiasm for what the person who's asking you to do something is trying to accomplish, and start the conversation with shared commitments. You can say to the other person, they're asking you to join a committee and you really don't have time. For example, you can say, I am really committed and I love the work that the committee is doing, and I really believe in the goals, and I want to work and help you further them. Then explain your current circumstances. You don't need to go into excruciating detail, but you can say, like, current COVID circumstances do not permit me to add anything to my plate at the moment. Third thing is express openness to revisiting the request or a similar request in the future. I'd love to revisit this maybe in a year or 6 months or whatever the time frame is, and then offer to help the requester find others who might be able to assist. So even on a daily work basis, if you have to, make the decision that you have to turn down one particular job, offer to find others who might be able to help carry the load. Next slide, please. I found that one particular boundary setting trouble spot during COVID really is that nighttime shutdown. And so I wanted to address that briefly for just a moment. I definitely struggled with this a lot, and pretty much at the beginning of September threw up my hands and said, like, I need a new way of turning off at night so that I can restore myself and not have just work bleed into everything. And so I came up with a system of actually, trying to shut down consistently every night. And it more or less has worked since the beginning of September. And for me, what has been helpful has been a couple of things. One, focusing on why I'm shutting down. I know that emotions are contagious, and that if I wake up grumpy and not well rested, that's going to, affect the rest of my household. And then I'm just not as effective or efficient at my job whenever I am not, haven't gotten enough sleep. Setting a declared time has really helped me. For me, the turn off time for my sort of second shift after my kids are in bed is 10:30. That's my boundary that I try to stick to. Having an accountability partner, telling my husband, 10:30, I'm shutting down, has really helped me to put me on the hook. It's not like he's knocking on my computer screen saying, hey, you need to turn off now, but I feel like I need to shut down because I've committed to shutting down. Having a shutdown mantra can help, work complete or shutdown complete or something like that to tell your brain you're done. And then having an enjoyable next activity has probably been the thing that's helped me most. So my husband and I had this sort of crisis point over the summer where we were just in a bad place. We're like, we really need to build some meditation and mindfulness into our days, but we don't have time. So now we decided when we shut down at 10:30, we're going to do 10 minutes of insight timer together on the couch and just breathe. And for me, that's something I really look forward to, a chance to reconnect with him for a few minutes. It calms me down right before bed. It could be anything, but just, what do you look forward to doing that isn't doom scrolling right before bed? Next slide, please. Okay, so this is just a final reminder on this whole notion of 24/7 availability and boundaries, which is quite frankly why we're all burned out in the first place. So back to deep work in Cal Newport. He was looking at a study that found that people actually do respect others' rights to become inaccessible if the periods are well defined, well advertised, and then outside of those stretches, you're once again easy to find. So in order to set those boundaries, it's all about communicating the boundary, letting people know when you won't and when you will be there, and then being consistent in being available when you've returned on the other side of the boundary. Next slide, please. All right, so I've just flown through a whole number of sort of a medley, a salad of options for you to try to help turn down the burnout a little bit. I really encourage you to just pick one thing that you want to start off with and try to make a habit around and give it a whirl for the next week. See how it goes. Tell someone else you're doing that one thing. Have an accountability partner. Put yourself on the hook. You'll be much, much more likely to actually stick with that thing if someone else knows that you're doing it. And I think my final slide is just a way to keep in touch with Mindful Return. I run a weekly newsletter called Saturday Secrets that you can feel free to sign up for on our website. You can follow along for some calming and empowering inspiration on our Instagram account and Facebook and Twitter, and check out our website. So thank you so much for having me. I'm happy to answer any questions if there's time for that, but I know I've gone a couple of minutes over and I'm going to hand it back to you, Rob.
And Lori, thank you. That was very valuable. And I do see, other than 2 technical support questions that I hope somebody more technologically competent than us could help with, we do have one question on the chat box from our very own Frank Chaikin from Chicago. And he asks, do you distinguish between finding a polite way to say no, depending on where on the Eisenhower matrix the request falls? What do you do when conflicting demands are both urgent and important?
Yeah, that's a great layering of the 2 concepts there. And I think we're all going to have things that are urgent and important all the time. I read a book not that long ago where the mantra in the book was, expectations are infinite. Time is finite. We are always choosing, choose well. So, you know, there is definitely the choice of which priority is higher in a given moment, and how can we triage and sort out the things that may not require you to do them, but may, you know, help someone else. And I think, quite frankly, it's just always an ongoing negotiation of shuffling priorities and pulling in people who can help with them. And I know that's not a satisfying answer, but I do think that it's a good overlay of thinking about what you need to say no to, at least in the short term. There are things you can say no to today that you can return to tomorrow if the timeline is long enough. But I think we have to grow both muscles of prioritization and of saying no to things that, quite frankly, can't serve us. We can't do all the things every day.
Thank you. That is probably about the best answer that you could give to something that broad. Frank is one of our thought leaders, and your contact information is up on the screen right now. So I have a feeling you may converse on that one a little bit more.
I'd love to hear from you, Frank.
Okay. Thank you so much, Lori. And I got your slides a couple of days ago and poured through them, and it's already been very helpful. And certainly sometimes something as simple as remembering breathing exercises can be extremely valuable. It's helped me, and it's probably ruining me as a litigator because I'm not as nasty on the phone anymore, but I'm trying to work through that right now.
I suspect you can be an effective litigator without being as nasty. All right, thank you.
And I hope, yes, thank you. I hope everybody took to heart Lori's message, and because I'm not going to try to scare you, but we're now moving into legal ethics and professional conduct at a social distance. And first question may be, why is this a topic? And the reality is the rules that obligate us as attorneys to our clients, to the courts if we appear in front of courts, to opposing counsel if we deal with other counsel, haven't changed as a result of the pandemic. To some extent, particularly with regard to people who have been working remotely or whose subordinates and staff have been working remotely, the procedures have changed. And there are, the bar associations have done a pretty good job of reminding us of this. Some of the Supreme Courts in various jurisdictions have been proactive on it. But for the remainder of our time, we're going to run through first some of the rules of professional conduct that are implicated by current status, and then some of the practical considerations that we run into. It doesn't necessarily result in possible discipline if you run afoul, but it could cause some reputational harm with your peers and with courts, again, if you appear in front of them. And jumping straight in, first and foremost, and probably not a huge surprise, maintaining client confidentiality in non-traditional environments is something that has been a major consideration for law firm management and lawyers. Why for? Well, when all else fails, take a look at the rules. Rule of Professional Conduct 1.6a is the basics on client confidences. You can't reveal information about your representation of a client, including, but not limited to, information protected by the attorney-client privilege, unless the client has given informed consent. Now, how have things gotten different? Well, if you're working from home, unless you live alone or live in a mansion, you have to take into account things that you don't necessarily in a law office. For those of us old hands, over the years, we have seen changes. When I started practice, partners had very large offices. They would bring clients back into the work areas. That's almost completely gone at this point. Part of it because law firms have recognized best practices is to be uber vigilant with regard to client confidences. So you don't want somebody, even a trusted client, walking through where something might be out where they could see it, or a file cabinet open and they could see something as seemingly innocuous as a client name on a file. And in some circumstances, your representation of a client in and of itself is something that should be held in confidence. We have gone from entertaining in offices to conference centers, have most assuredly increased our computer security. There are some instances where clients insist on clean desk rules, where everything is off the desk before you leave, so even the nighttime cleaning staff can't see things. That all gets very different if you are working from home. And it's not only overt exposure of client information that Rule of Professional Conduct 1.6 prohibits, but 1.6c also relates to inadvertent disclosure. It's basically strict liability, and you cannot, under any circumstances, let something slip. So what kind of steps are being recommended? And this comes from, well, both our internal practices as well as a lot of advisory bar opinions. If you're working in a remote atmosphere, you absolutely need to have a secure room. And this isn't just something with a door that closes. This is something that has walls sufficient that somebody standing on the outside isn't going to inadvertently hear things. One thing that a lot of you working remotely probably figured out fairly quickly is conference calls and video conferences get interesting unless you're in a very secure area, because voices do carry. So speakerphones can be the enemy. Earbuds are definitely your friend. And if all else fails, you become, once again, up close and personal with your handset, because you may have to use that even though you probably have been doing almost solely hands-free calls for a decade or more. Public Wi-Fi is a no-no if you're using your own. I mean, I think most of us are sophisticated at this point that our neighbors aren't sitting at the end of the driveway and being able to leech off of it, but having secure passwords is very important. Having a virtual personal network, a VPN, which we offer, as do many other firms and businesses, is great for security. Strong passwords are important, and for most of your systems, two-factor or multi-factor authentication is desirable. And I can tell you on this, you don't just talk the talk, you need to walk it as well. My example, no blood, no foul, but about a month and a half ago, I was in a virtual mediation on Zoom. Worked out very well, actually, because I was in Cincinnati, opposing counsel was in Columbus, Ohio. My client representative was in Louisville, Kentucky. Opposing counsel's client representative was in Nashville, Tennessee. And the mediator was in an office separate from opposing counsel in Columbus as well. Mediator, who did a great job, very sanctimoniously admonished us and questioned us on the security of our locations, because mediations are confidential. And he went down to the point of, if you are working from home, you cannot have children around, you shouldn't even have your pets in the room. And almost on cue, immediately after he finished this, and he had assured us, I am in my office and I am the only person here, behind him comes the looming form of the UPS delivery driver who was looking for a signature on packages he had just delivered. Fortunately, we weren't doing anything confidential, but the mediator had forgotten to close his door. So one thing, and I almost hesitate to bring it up since we are on a video conference with 167 people, and this was open invitation because it is a public CLE. If you're video conferencing, make sure you are secure. This, to be fair, is more of an issue, I think, for the courts than anything else, and I can promise you we've got everybody's audio locked down and we've got good security on this. And I looked at the RSVP list and I know a couple of people were probably contemplating, given the topic, maybe. No, I'm pretty sure we're good, but feel free to try. What is Zoom bombing? It's nothing against that particular application, but it is a phenomenon under which, either because in the case of courts or other public entities, county commission meetings, city council meetings, public participation, or at least public viewing, is allowed and even encouraged. There have been times, often because the administrators didn't have the sophistication, where, let's say, things went wrong. And I'm not trying to pick on either Zoom or video in general. We went into this with courts under an awful lot of circumstances. Some of you may have seen the very first United States Supreme Court virtual argument took place on May 6th of this year. And a lot of people have forgotten that the case that was argued was on the topic of the constitutionality of restrictions on robocallers, and the court ultimately carved out part of the statute and said you can't allow it for some but not for others. What everybody remembers about that argument, though, is that while counsel for the robocallers was speaking, perhaps editorial comment, perhaps not, the very audible sound of a toilet flushing interrupted the proceedings. We, to this day, do not know who that was, but somebody wasn't following best practices. Starting about August of this year, it almost got to be a hobby for a while, where you would have hackers come in and do what they call Zoom bombing, and either their audio was not locked down, so you started getting music. People would start posting videos, usually adult content, which I guess is what happens when people get bored. Unsurprisingly, it happened through August and September, first in a hearing for a teenage Twitter hacker in the Middle District of Florida, where all of a sudden the screen was flooded with pornographic images. In a September hearing in a federal court in Georgia, which kind of presaged all of the post-election litigation we're having, this one was over electronic voting machines, which was held on September 11, and somebody came in playing music and then posting 9/11 imagery and then what was supposedly Al-Qaeda propaganda. One of the counties near Chicago, Lake County, which used to broadcast its court proceedings over a YouTube channel, found itself getting interrupted so often that they created their own proprietary video platform, so it would be easier for them to lock out anybody except for people who were scheduled to speak. It's still not a perfect system, and a lot of courts are not even using video for virtual hearings. They're using telephones, which are a little bit harder to control. And I had an oral argument in October in the Southern District of New York, 2 hours with one of the senior judges, and in the midst of it, we were interrupted by somebody's dog barking. And to this day, I don't know whether it was somebody who was listening in or one of the litigants. I was in the office, so not guilty. The takeaway there is talk with your tech support and make sure that you're adequately supported and you have adequate security when you're doing things, whether they be business calls or presentations like this. Moving on to a different section of the rules, another consideration beyond maintaining confidentiality is what do you do when all of a sudden some or all of your staff is working remotely? How do you make sure people are really working? And more importantly, how do you look after people? And of course, communication is a key here. Now, you might be saying, look, we know because the work either gets done or it doesn't. If you're in private practice, you can see people either are or are not billing, they are or are not producing work product. But it goes a little bit beyond just making sure that people are hard at work, because if you're supervising anybody, you do have professional responsibilities associated with it. And specifically, Rule 5.1, and I am basing this, incidentally, off of the ABA Rules of Professional Conduct. For those of you who are viewing from Ohio, everything I'm showing you has been adopted verbatim. And in pretty much every other jurisdiction, rules of confidentiality are reasonably uniform throughout the country, and responsibilities to supervise your people are too. Now, under Rule 5.1, if you are a partner in a private law firm supervising, if you are an attorney in governmental practice, or if you are an attorney who supervises other attorneys, so that includes people working in-house, you are responsible if you know of misconduct that has occurred and fail to take steps to mitigate it or prevent damage from it. So you do need to be very careful to look out for folks who are working under you. It doesn't simply extend to associates, junior attorneys. Rule 5.3 also deals with non-attorney staff, and the rules are exactly the same. You are also, even remotely, responsible for ensuring the competence of the people who are working under you. And unsurprisingly, Rule 1.1, right at the beginning of the Rules of Professional Conduct, requires lawyers to provide competent representation to a client, and it requires the knowledge. You have to know the subject matter. Skill, you have to be experienced enough to do it. Thoroughness, you have to be diligent. And preparation, you have to have the time to do it. And think back to the Eisenhower chart that Lori showed you. That's reasonably necessary for the representation. Why do I bring that up in this context of making sure people are working and are working competently? Well, it's interesting because this does implicate remote practice. Pennsylvania, and I don't know if anybody on this conference is admitted in Pennsylvania, but your bar association, if you are, has been extraordinarily proactive in issuing formal opinions on a number of areas regarding remote practice. And one thing that, and these are usually in response to questions that come from the members of the bar, and they have recognized that that duty of competence, Rule of Professional Conduct 1.1, does extend to ensuring that attorneys utilize the technology that is necessary to protect their client information. So everything kind of runs in a circle. That slide that I showed you regarding private rooms and VPNs and no public Wi-Fi extends to a lot of things with regard to your competence as well. Now, how do you maintain that when you're not in the same office suite as your people? And this one may seem fairly obvious, but I'd respectfully suggest reach out to folks. This extends into mindfulness as well. If you're supervising staff and attorneys, or either, pick up the phone occasionally. I think most of us have figured out that just kind of random video calls aren't necessarily welcome, but check in with your folks. Find out if they have any issues and find out whether or not they need anything. Are they underwater? Are they down in a well? As supervising attorneys, we're not just there to manage the work. We should be there to try to lend some guidance to our people. Now, how does this potentially work in practice with issues of competence? Because it's not just protecting client confidential information that falls into the duty of competence. You better know how to use your systems. And if you are working remotely, you'd better have what you need to be able to get the job done. We recently had an interesting example of this, although ultimately the Sixth Circuit Court of Appeals went a little bit easy on the attorney. The case caption that I've got up is Sands versus Kohl's Department Store, Sixth Circuit case decided a month ago, coming out of the Eastern District of Michigan. And the underlying case is pretty plain vanilla. It was a slip and fall, diversity of citizenship, so it ended up in federal court. And First Defense Counsel made the error of providing unverified interrogatory responses at one point without having the client say, yes, all the information is correct. And there was some incorrect information in the unverified that was corrected with the verified, which of course is the only form of an interrogatory that you can submit as evidence. And the difference was fairly significant. It dealt with whether or not there was notice to the department store of a wet spot on the floor, and specifically whether there was a warning sign that was put up that supposedly was not put up adequately. Plaintiff's counsel incorrectly cited to the unverified responses in response to the defendant's motion for summary judgment, and that was pointed out by defense counsel. Court granted the motion for summary judgment. Plaintiff takes an appeal and then makes exactly the same mistake in their brief. So in response, defense counsel not only files an appellee's brief saying, please affirm, which the court did, they also file a sanctions motion. You might get one bite, but you don't get two. And there is a somewhat lengthy discussion. More of the opinion relates to the sanctions motion than it does to the affirmance of the underlying case. And it's very interesting because ultimately, as I said, I think that the court bailed out appellant's counsel and said, you know, we appreciate these are trying times. And this is after saying you screwed up, counsel. And they note a Michigan stay-at-home order was in effect at the time. Sands filed this appeal, which may have limited her attorney's access to the record. And that was good of the court to do. I would also point out, for those who don't practice in federal court, and particularly in the Court of Appeals, for years now, the entire record on appeal, which is everything from the district court case that will be considered, transferred to the Court of Appeals and considered, is available online. There should have been no reason to have any kind of difficulty in accessing the record. I'm sure that the three judges who issued this opinion knew that anybody reading this would know it. They just decided to cut them a break. But it could have been a sanctions liability and potentially even a disciplinary liability, which it may still be for the attorney. So keep in mind, even for those of us who remember the days of IBM Selectric typewriters, you need to keep up with the technology, or at least make sure that you've got access to somebody who does. Let's segue a little bit. We've been talking about the rules of professional conduct. Now let's take some time and talk about the practical applications of remote practice and just in general, the situation that the pandemic has put us in. And the title, Professionalism in the Remote Courtroom, Shoes and Shirts Required, might sound a little bit snarky, but it really isn't, because we've seen instances, one in particular, and yes, for regular attendees of this seminar, this is a Florida example. There has to be at least one of them in all of my professional conduct presentations. It is amazing how fast we can devolve into our state of nature when we're not going into the office every day. And our backdrop on this is a circuit judge in Broward County, Florida, Dennis Daly, whose courtroom is general division, which means it hears the equivalent of what in Ohio would be common pleas cases. So civil cases, criminal cases, sounds like he's got some domestic relations dockets that he runs as well. He felt the need to put up a blog post for the County Bar Association discussing first with counsel what they needed to make sure their clients who were appearing virtually needed to do with regard to behavior, including proper dress, proper decorum in addressing the court. And then he moved on to how remarkable it is how many attorneys appear inappropriately on camera. And we're not just talking about whether or not you're wearing a necktie. That seemed to be well outside the scope of Judge Daly's complaints. He went on to note one male attorney appearing shirtless. Think about the people you work with. I love my coworkers. I don't want to see that. I think about the bar locally. I really don't want to see that. One female attorney appeared in bed, still under the covers. And this is Florida. It even got more so. Putting on a beach cover-up won't cover up your poolside in a bathing suit. And I should have put a 6 next to your, because, yeah, the judge did have that typo in there. The post is worth tracking down because it is rather exceptional. And I looked and I never saw any pushback from any attorneys in Florida saying he overstated that. And no, they seem to say, yeah, these are our people. And going back to video, if you don't know who Jeffrey Toobin is, or if you were focused on billable work a month plus ago, about 2 months back, Jeff Toobin he used to be a practicing attorney back 80s, maybe early 90s, became a TV attorney around the advent of court TV and the OJ trial, has written a few books, commentator on CNN regularly, wrote for the New Yorker, and he found himself in October of this year taking part in an election simulation that was sponsored by the New Yorker and public radio station WNYC. And different of the heavy hitters on the staff of both entities were playing different roles. There was somebody assigned to play Donald Trump, somebody to play Joe Biden. There were people who were there to play constituencies, the Republican National Committee, the Democratic National Committee, the right wing of the Republican Party, the left wing of the Democratic Party, and Toobin's role was to play the role of the judiciary. So I will say in advance, this is not editorial comment. He was playing the judiciary and apparently got bored. And for those of you who engage in Zoom or other conferencing, you know there are private rooms. And there was a point in the proceedings in which other constituents, I think the political parties, went into private rooms to discuss things. And apparently, Mr. Toobin decided to engage in his own simulation. And this is not supposed to be a recurring theme of this presentation, but here we go. Apparently dialed up some adult entertainment, and let's just say he didn't realize that he was still visible to this day, unknown number of other participants in the simulation, this being the electoral simulation, not the private simulation. And he got caught. He basically Zoom bombed everybody else, and we'll see how it shakes out, but he's no longer affiliated with the New Yorker and is at least on a timeout with regard to CNN. On the good news, he does have a good topic for the next book, perhaps. So that covers the behavior when you're in court or a court simulation. It's also worth a moment to discuss the need to respect the limited resources that the court system has during the pandemic. And this one, in putting this together, it struck pretty close to home. Had a few flashbacks that I didn't like, and I'm going to spread them on to you. As you'll recall, things happened really quickly in the first quarter of 2020. And from a personal standpoint, it went from February 26th, I was in San Francisco, California for a Court of Appeals argument. That evening in the airport, waiting for my flight back to Cincinnati, it was announced that they had the first confirmed San Francisco Bay Area case of community spread of COVID-19. They knew they had cases. Up to that point, the only ones they had confirmed were from people who had recently returned from China. Now, as we know now, it had been there for a couple of months, and there were even some fatalities leading up to several weeks earlier. 2 weeks to the day after that day, the United States District Courts for the Southern District of Ohio and Eastern District of Kentucky, which are the two that I primarily practice in, along with several others around the country, announced that they were going virtual for all but emergency bases, and they were suspending jury trials, including criminal trials, with the chief judge of each district announcing that they had just cause to suspend Speedy Trial Act considerations. Friday the 13th, March 13th, was the last day that I appeared in a courtroom of any stripe physically without wearing a mask, and that was in one of the state courts of Kentucky. That was the last day that the courts of Kentucky held live proceedings, except for on an emergency basis, for quite some time by order of the Chief Justice of the State Supreme Court. This was happening all over the country, and things came to a screeching halt, and it took some attorneys a while to get with the program on that, which led to a lot of irritation with the courts. The first thing that you saw, and mercifully in these parts, we didn't see very much of this, but you did at least anecdotally see a number of cases in which overly aggressive counsel attempted to force live depositions, sometimes requiring witnesses to travel for those depositions. There were instances that got a fair amount of publicity against a court in Florida, and at least one instance I know of in federal court in New York. They were very quickly slapped down by judges in very brusque terms. The only one I know of that we had in this office that got anywhere remotely that close was from some good old boy, I think from St. Louis, a plaintiff's asbestos attorney who was trying to enforce a non-party subpoena on one of our clients to appear physically at a conference room in a downtown Cincinnati hotel for a deposition, and they were quite persistent on it. And finally, when we told them that because of the order then in place from Governor DeWine at the time, if he wanted that deposition live, he was going to have to show up 2 weeks in advance and quarantine before he could see our witness, and that, yeah, we were going to demand to see the receipt, so we knew he had actually done it. And at that point, all of a sudden, video deposition became quite reasonable in his mind. It went beyond that, and aside from needless discovery motions, what really started antagonizing courts in some instances was attorneys who were demanding instant consideration of their motions. And we have one example to discuss briefly, the Art Ask Agency, which is a online vendor of artwork. And when your caption has them versus the individual corporations, limited liability companies, partnerships, and unincorporated associations identified on Schedule A, which to my recollection was at least 10 pages long on the complaint, you know that you're in for something. The issue that Art Ask Agency wanted to bring to the court's attention was a copyright infringement suit And I don't judge, but it involved basically unicorn paintings, fantasy art, and maybe there was a demand on that as the world was spinning out of control. I don't know. But the agency had a rather big ask. They filed their complaint in March of this year in the Northern District of Illinois, just as things were shutting down and going remote, and the courts were scrambling just as much as businesses and private practice and other governmental agencies were to figure out how they were going to keep things running and to what extent they could. And the plaintiff in this case filed a rather aggressive motion for temporary restraining order. They didn't just sue the alleged copyright pirates. They also went after pretty much every possible distributor, every platform, including Amazon, every search engine upon which the pirates' offerings may be found, which would include Google, Yahoo, and any number of other search engines. Basically, a number of entities that had no idea there was any dispute going on, that hadn't even been served with a complaint yet, obviously, but they wanted them to immediately take heroic efforts to stop any possible distribution of these pirated unicorn paintings. The Judge Stephen Seeger, who was pretty new to the bench at that point, had been on for about 6 months, very dutifully set a status conference out for some point in April and didn't immediately consider the motion, at which point the plaintiff filed a motion for reconsideration of the scheduling order, and then when that didn't get immediate action, turned around and went to the chief administrative judge for the Northern District and tried to do an end around Judge Seeger. And that got the good judge's attention, and he wasn't happy about it, and so counsel for our task agency now has a very scathing opinion, which does note the court can still hear emergency motions, but resources are stretched. Time is at a premium. If there's ever a time when emergency motions should be limited to genuine emergencies, now is the time. And this is the point at which the good judge basically advised plaintiff's counsel why he was going to lose on most of the relief he sought anyway. First off, you're dealing with copyright infringement. Presumably, somebody is selling pirated artwork. You normally only get an injunction when damages wouldn't be an adequate remedy, and this screams out as an instance where damages would be an adequate remedy. And a problem with that, nothing in the pleadings indicated that the plaintiff had any idea as to whether it had actually been damaged. There were allegedly infringing works of art that were offered for sale. There was no indication as to whether any sales had ensued, and if so, whether that had cut into the sales that the agency would have otherwise gotten. And finally, oh yeah, there's a pandemic going on, and there's no way that you're ever going to get a court in the best of times to order parties that have no culpability to basically change all of their algorithms to make sure that every single possibly infringing party is off of their platform. So as the court concluded, the world is facing a real emergency. Plaintiff is not. The motion to reconsider the scheduling order is denied, and I checked the docket. Ain't nothing happening on that case months later. Lesson on that, don't be too pushy. The courts really, by and large, are doing their best on this. If you've got an emergency, save your powder for when you need to bring that to the court's attention. However, you can run into issues in the other direction as well when you are trying to use the pandemic as an excuse to slow things down. And our example on this one is a case, a criminal case in the Northern District of California, United States versus Elizabeth Holmes and Ramesh Sunny Balwani. And if those names aren't familiar to you, there's a company called Theranos out of Silicon Valley, which once upon a time came out with what was said to be a revolutionary blood testing product. It was a handheld device, which the selling points were that it could operate on an extremely small volume of blood, number one. Didn't need a full vial. A couple of drops would be enough. And number two, it could yield results remarkably quickly. And the plan was to roll out these devices in Walgreens and other drugstores for very rapid testing. The problem is, in a best case scenario, the Theranos product didn't work. And in the worst case, it was just a complete fraud. And as a result, Ms. Holmes, who was the CEO of the company, and Mr. Balwani, who was the chief financial officer, are now up on criminal charges for securities fraud. And at the time that the decision at issue here was rendered, the case was scheduled to go to trial beginning August 4th of this past summer. Ms. Holmes was represented by an excellent DC firm that I have worked with and respect too much to give the name. Very good white-collar crime practice, excellent litigation practice, but they clearly, as defense counsel are wont to be, did not want to try the case in August. And so they filed a very interesting motion seeking some special dispensations for the court to allow them, as they said, to undertake the onerous task of trial preparation during a pandemic. And their motion started off with a little bit of humble speak that our struggles pale by comparison to those experienced by the afflicted, those who are treating them, or those who have been displaced as a result of the crisis. And then they started knitting the flag. And this reads better if you do it in the voice of an antebellum Southerner talking about states' rights. Just go very dramatic, because they then proceed into the circumstances do, however, make preparing for a complex, months-long trial such as this extremely difficult, and proceeded to ask the court for a ridiculous litany of allowances that they wanted reduced to an order, because they assured the court, we need to meet with every witness, they're across the country, face-to-face. We may run afoul of lockdown orders. We may run afoul of quarantine orders, and we want a get-out-of-jail-free card if you decline to move the trial date. In this case, they had an experienced judge, Judge Edward Davila, who was having none of it. And the judge held a hearing, noted that for all of their protestations about needing physical proximity to prep witnesses and prepare for trial, that the defense attorneys seemed to have really good capability for appearing by video with the court, and the picture was perfect, sound quality was excellent. And ultimately, court said, I think perhaps we should have a rational discussion, as opposed to, if you want the trial, this is what you need to do. So the Godfather crossed with my cousin Vinny approach was not appreciated by the court. Ultimately, certainly no sanction for the court. He denied the motion, kept a wait-and-see approach on the trial, which still has not occurred. It's been moved twice, and the last I saw, Ms. Holmes and Mr. Balwani are scheduled to commence their trial. I think it's the week of March 9th of 2021, and we'll see what happens. But just from a professional reputation perspective, probably not a great look for defense counsel to plead inability, in effect, to prepare when they have state-of-the-art technology and some of the most skilled attorneys in the country. So speaking of trials, I am a courtroom-facing litigator, and I've certainly had an awful lot of stuff get continued. Courts are doing their best. So we are learning an awful lot, and that brings us to our last topic. What do you do? Remote jury trials, virtually what else? And I can tell you, video depositions, by and large, work pretty well. have done a number of them. The savvier court reporters have excellent document sharing platforms. We haven't missed a beat, and we probably actually saved clients some money on business travel. That's going to probably stay in our arsenal. Virtual mediations. It's hit and miss. If you're doing business litigation, which is the vast majority of what I do, it can work pretty well because chances are you've got a sophisticated client on either side. You don't need to have the mediator necessarily in the same room, and as long as your mediator is up to date on the technology, which all of the ones that I've dealt with have been, you can have privacy in separate chat rooms. Virtual arguments, it's been interesting. Courts have done everything from, I've done live oral argument in federal court with an enormous amount of plexiglass around everything, windsocks over the microphones so they would not have to possibly gum them up with disinfectant. As I mentioned earlier, we've done telephonic, which works. It's a little bit disorienting to spend 2 hours on the phone with the court arguing. Have done some video, but by and large, those preliminaries can work. Virtual bench trials, that's a new frontier, but you could probably manage that. And I know anecdotally of a few places where that's been done successfully. It probably works best if you could get everything in within a couple of days and there aren't too many documents, and you've got to have a very attentive judge. But then we get into virtual jury trials, and that's when I start contemplating the fact that there are other things to do with my life other than to be a trial attorney. Nevertheless, some have been done to varying degrees of success. One of the most noteworthy examples of it has been in the state courts out in California, particularly, again, Bay Area, where they've got a large asbestos docket, and they started moving those cases forward late this summer. They've done at least 2 that have gone to jury that I know of. The first one, the Wilgenbush case, and what normally happens on the asbestos cases is the entire world gets sued, and some of the parties settle, some are voluntarily dismissed because the plaintiff can't ID proximity with any product. Some defendants win on summary judgment because they can prove, or the plaintiffs can't prove, product ID. And usually it's a fairly small handful of cases or defendants that elect to go to trial. And this was what happened in the Wilgenbush case. There were only a couple of defendants, and one in particular was not happy about it and started filing mistrial motions almost immediately. And it started actually on the first day of jury selection. This Alameda County is East Bay. It's Oakland, Berkeley, Fremont, Hayward. And I've had the pleasure of trying a case in the Oakland courthouse, and I'm probably sitting in a larger room right now than the courtroom. You cannot socially distance there. So for some strange reason, on the first day of jury selection, the court did have a few jurors in. And one of the defense attorneys tried to drive over from San Francisco and found himself locked out of the courtroom. And they filed a motion for mistrial based on that. He had co-counsel back in the office who apparently lost audio a couple of times, and that was a little bit problematic. That motion was denied. Then there was a second one arising from the virtual jury selection part, where the motion notes, among other things, that during portions of voir dire, one jury was laying on what appeared to be a bed, curled up and possibly asleep. And they did actually give my number, that juror. Noted another juror had a child in the room, and the juror was in and out with the child. There was another juror who was working out on an elliptical machine. There was another one who was apparently cooking, and there was another one, several of them apparently were playing on their devices while jury selection was going on. And I can tell you, you're never going to try a jury case without having somebody who actually gets onto the jury sleeping at some point. They're not all going to be attentive, but this is fairly daunting. The court denied every single motion for mistrial. Interestingly, this case went to jury, it went to verdict, and the jury came back with a defense verdict. So presumably no appeal from the defense, and they said never mind on the mistrial motions. I can also report there was another case involving a retired naval admiral who claimed to have contracted an asbestos-related illness because of exposure while in the service. And there was a little bit of an incident because during a sidebar, during jury selection, which was conducted in a private room on video, the good admiral / plaintiff started engaging members of the prospective jury in conversation. That one came back with a $2 million verdict in favor of the plaintiff. I'm going to take a wild guess that one of the issues on appeal is going to be that. Okay, but what happens if you're not willing to do your case or try your case virtually? Are you willing to risk a live experience? Well, we got an example for that one too, which will be our final one. And this one brings us to the Eastern District of Texas, Marshall, Texas, which I had to look up. Marshall is 174 miles from the Dallas-Fort Worth Airport, 204 miles from Houston's Bush Intercontinental Airport. It's actually, I think, closer to Shreveport, Louisiana, than any commercial airport in Texas. And even there, you got more than an hour drive and probably a connection. As the name suggests, Optus wireless technology versus Apple, this is a patent case. And a lot of patent cases get filed in the Eastern District. It's known for being very plaintiffs friendly. Most recent stats I had were through 2018 that of cases that go to trial in the patent field, 78% result in plaintiffs' verdicts. This case was scheduled to begin trial at the end of July of this year. And there were 7 law firms involved between the two parties. It related to 4G technology, supposedly infringed upon through several iterations of the Apple iPhone. And Apple, noting pandemic, noting multiple witnesses who were overseas who would otherwise have to testify by video, asked for a 2-month continuation, and that was opposed, of course, by Optus, and Judge Rodney Gilstrap of the Eastern District wrote a lengthy opinion and noted, the task of balancing real public health concerns against the rights of the party to resolve far-reaching disputes is a challenge the court hasn't sought and does not relish. And then he proceeded to spend most of the rest of the opinion talking about all the great precautions that his staff had with regard to distancing. I suspect his courtroom had even more plexiglass than I saw in Judge Cole's courtroom in early October of this year. They had plexiglass between the jurors. Everybody was going to be masked up except when speaking. Hand sanitizer on every table. Temperatures taken every day at the courthouse door as part of the security, which is pretty common now. And and he ordered all of the attorneys to be present in Marshall on the Friday before the jury selection was going to begin the following week to make sure everyone had time to acclimate and make sure they didn't bring any unwelcome visitors in with them. And the judge concludes, when all else fails, quoting Robert Frost, always pleases, as Robert Frost admonished in A Servant to Servants, the best way out is always through. And one can question whether or not, if Robert Frost saw a burning building and didn't have to walk into it, whether he would have thought, let's just go around it instead of through it. However, for our own purposes, given that we see the light at the end of the tunnel, but we're not out of the tunnel yet, that's a good closing thought for all of us. We're in this, let's try to get through it. Oh, the trial did take place, by the way, resulted in a $506 million verdict in favor of the plaintiffs. So the 78% plaintiffs holds. And while that might be pocket change for Apple, they are still briefing, last I saw, the proposed findings of fact and conclusions of law on certain declaratory judgment issues that Judge Gilstrap will consider, and Apple has vowed to appeal. So while I scan on questions, and I see that there are a few, our CLE tracking code, those of you who have the video up can see it, DEC03. And for those of you who can't, I just told you. And if there are any concerns on how to do this, please follow up with our staff. Elise can help you out. And thank you for all of your time. I do see we have a couple of questions that I can try to get to, but everybody has earned their hour and a half now. For those who want to stay, let me see if I can manage to bring them up. Rob, as an experienced interrogator, you're too kind, do you give any credence to the argument that being in the room with the witness, seeing the sweat bead on their forehead, their shifting eyes, body language, etc., versus a remote video conversation has material impact / value? That's an excellent question, Frank, and the answer is yes. There definitely are depositions that you do not want to take virtually. And it takes some practice to be any good at a virtual deposition, even with a witness who is not too shifty. But yes, there are definitely some, and I have actually taken a couple of live depositions this year for that very reason. If you know somebody who's going to be greasy, or if you need to check sincerity, if you absolutely know you're going to go to trial and it's a key witness, biting the bullet and finding a way to do it live is a good idea. Next question, Ray, the Theranos example where the client's freedom is on the line. Frank has some sympathy for counsel's argument, if not their tactics with the judge, and that's absolutely true. There's a lot of speculation going on right now as to whether this experience is going to change how juries look at things. I have seen mediators use that as a club trying to tell people jurors have their own thing going on and they're not going to have sympathy for somebody who wants, you know, millions and millions of dollars in damages. I have seen some pretty thinly sourced research from some psychologists, and it's only in limited markets, mainly the larger ones, New York, Chicago, LA, San Francisco, and Atlanta come to mind, where they claim that people in the future are going to be more empathetic and be more likely to give large verdicts. My guess on this would be when it is a criminal case and the freedom of the accused is on the line, you might have some people giving some very sincere thought, but we don't know. But at any rate, yeah, and again, I'm not trying to slag on that law firm because, again, I've worked with their attorneys. They're excellent. They just were a little bit overwrought. I have sympathy for anybody who is trying to get a good faith continuance. They might have, if they had just played their cards right in this case, they would have been able to get there without having to knit the flag the way that they did. And then I think this is our last one. Does the lack / infrequency of TRO hearings during the pandemic suggest that most TRO hearings for other emergency hearings are not necessary? Will that be an effect of the pandemic on future emergency motions? Will the code, oh, I'm sorry, and somebody else wanted to know if the code will be provided, and it has been now. in answer to Jack's question, I think that the key here is it is a little bit different than, okay, if you're in Hamilton County, Ohio, and you've got the equity judge, and there's one judge who just does, I hear my TROs on this day, and there's a, it doesn't hurt to ask. What we're seeing is that courts are probably more finely honing their willingness to hear motions. The reason I use the Art Ask agency case is it was just an example of something so ridiculous, because there was, even if it's a valid case, and let's assume that there is a pirate, it didn't need to be decided while the court was in the process of going virtual, of figuring out what its practices were going to be. You have to consider, on the federal level and in most state courts, these judges are hearing civil and criminal cases. This was a crisis, not only a health crisis, but a legal crisis. How do you do arraignments? How long can you keep somebody locked up? The courts were grappling with this, and they took it very seriously. So the reason I use that example was less because you're not going to get a TRO. We've actually had attorneys in our office and elsewhere in the firm who, through various means, have obtained and resisted injunctive relief while all of this was going on. The key is, when you're in a crisis mode, don't act the way that attorney did, because unlike the defense counsel in the Theranos criminal prosecution, these people in the Art Ask case did everything that they possibly could to poison the well against them. I don't think it's by any means the end of the era of injunctive relief, but as always, don't push the court when there's no reason to, and don't do it when it is seriously overtaxed. And finally, we do have a couple of questions up on claiming the CLE credit, so I'm going to read again for those still on who might be having any problem. There is a form that you need to fill out. It is located on the Go-To Webinar Control Panel, which should be up in the upper right corner of your screen. If you're missing that, there should be a red arrow up at the top of the screen that will expand the control panel. Several of you have found it because you've been putting some stuff in on the chat box, but there is a form on there that you will need to download, fill it out. There are instructions on the form, and proceed from there. Again, the code, if you don't have video on your screen, is DEC03. And if you don't have anything, and I know a couple of people are saying that the link to the document is not working, but if you have any problem, please contact Elise Hoffer. It's ELISE.HOFFER at thompsonhine.com. Again, ELISE.HOFFER at thompsonhine.com. And Elise can send the form if you have any problems. And I do know it takes a little while to be able to download. Just need to be a little bit patient. And finally, for my dear friend Pat Mohan, who wants me to do the Southern accent again, on my honor, sir, it has been a privilege to appear in front of all of you today and present our humble program. So thank you all, and we'll keep this live, I think, for a bit so people can finish their forms. And thank you for your time. Enjoy the rest of your day.